To be honest, breaking up a relationship is not easy, but even more difficult is starting a legal battle, especially when one side simply doesn't give consent for divorce. Often, many people ask, what should I do if my partner doesn't want to grant a divorce? Can I file for divorce alone? What is the procedure and how long does it take? I know that when a spouse is not agreeable to staying together, getting a mutual consent divorce becomes impossible. In such a scenario, you are left with only one option: to battle in family court. So today, we will understand step by step the one-party divorce process, which is also called contested divorce, meaning when only you want divorce and the other partner is opposing it, and the biggest truth: how much time this process takes. Let's start with the very first question. 1. What is one-party divorce? Understanding the difference. First, let's clear the confusion. There are primarily two types of divorce. First, mutual consent divorce, when both husband and wife are agreeable to separate. This is easy and gets complete quickly. Second, one-party divorce, also called contested divorce. This happens when only one party wants the divorce and the other party doesn't agree or is not available. This is the divorce where the court listens to why you want divorce alone and what grounds you have. This means that for one-party divorce, you have to prove solid and valid legal grounds. Now, you might be wondering what grounds are. It is not enough to simply tell the court that you are not happy in this marriage and do not want to live together anymore. You must provide a valid legal ground with proof along with your desire. So, under the Hindu Marriage Act 1955, certain grounds for divorce are provided, such as cruelty, physical or mental torture that can be proved; desertion, when the spouse has left you without any reasonable cause and this period has exceeded 2 years; adultery, when the spouse has a sexual relationship with someone else. In addition, if your spouse has converted their religion or is suffering from an incurable disease, has an unsound mind, or is impotent. If any one of these reasons exists and you have solid proof for it, you will get the divorce. 2. Family court procedure. 6 main phases. Now let's talk about the procedure. The 6 main phases of a contested divorce are as follows. First, preparation and notice. You will hire a wise and knowledgeable advocate and send a notice for divorce to your partner. Second, filing the petition now. Whether the reply to this notice comes or not, you will then file the divorce petition through an advocate in your district's family court. Following this, the court sends summons, notice to your spouse. Third, summons and appearance. Now, when the court sends a summons to your partner, 2 conditions can arise. Condition 1, non-appearance. If they do not appear in court, the court will send them summons again. If they continue to ignore coming to court after 3 or 4 summons, the court may grant you an ex parte divorce. Condition 2, appearance. After receiving the summons, they appear in court. If they appear in court, the court often sends your matter for mediation during the first hearing. Fourth, mediation phase. Now, you will have 3 or 4 mediation sessions. If reconciliation happens, great. And if not, you will receive a mediation failure report and you will take that back to the same family court. Fifth, evidence and cross-examination. Now your hearing will begin and your written statement will be submitted and the arguments of both parties will be heard. The court will give you and your partner a chance to present your side with proof. As evidence, you can present emails, messages, audio recordings, medical reports, or witness statements. After this, cross-examination takes place, where the lawyer does questioning of the witnesses. This phase is the most lengthy. Sixth, argument and final judgment. When the evidence is complete, the lawyers of both parties put forth their final arguments. After this, the judge gives the final judgment based on the merits of the case. Therefore, be careful. If your evidence is weak, getting divorced becomes difficult. Before filing a one-party divorce petition, collect solid proof, otherwise time and money will both be lost, and mental and physical harassment will be added on top. And yes, even after solid proof, if you lose the case, don't panic, because this is not the end of justice. After this, you can appeal against this judgment in the High Court. 3. How much time does one-party divorce take? This is the question that everyone asks, and its truth is emotionally challenging. Well, there's absolutely no fixed time period for this, but generally, assume 2 to 5 years. Look, the foundation of your one-party divorce or contested divorce rests upon your grounds. If your grounds do not have solid proof, your case will not only be long, but its result will also not be in your favor. So if you collect solid proof before filing the divorce case and bring some eyewitnesses in your favor, you will get the divorce decree quickly. That's all for this video. If you liked it and want more such information, don't forget to like, share, comment, and subscribe. We will meet in the next video with a new topic.